Hey, this is Jeremy, and today we're going to be talking about negligence. Now, negligence is the failure to take proper care in doing something that results in injury or damage to another. And the way this is relating to us in EMS is essentially you don't do something or you do something that resulted in harm to another person or resulted in some form of injury. Now, for negligence to be proven, four things must occur. You must have a duty to act, you must have a breach of duty, you must have causation, and you must have damages. Now, duty to act is that the way that that's looked at is, did you have a legal obligation to provide care for your community or the person that you provided care to? And we'll get into that a little bit more here in a minute. But if you are on shift, then you're getting paid by your service, and your service has a legal obligation to provide care to the citizens of that community. All right. Now, there is some states, some circumstances where even if you are off shift, then you have a legal obligation, a duty to act, even if you see something. So, for example, if you are off shift in these states and you pass by a wreck that you saw on the interstate, then you had a duty to act to stop at that wreck and help them. In Georgia, that is not the case. Your duty to act is only enforced whenever you are actually on shift at your place of employment. Now, you must also have that breach of duty. Breach of duty is the person that is getting accused of negligence. They failed to act in a way that somebody of similar training would have done under the same or similar circumstances. Now, this goes two different ways. It may involve doing less than what you were trained to do, or it may involve doing more than what you were trained to do. For example, they have an error of omission and an error of commission. Now, the error of omission, that is doing less than what you were trained to do. So, for example, that is not controlling the bleeding of an injured extremity. That is not splinting an injured extremity. That may include not putting somebody on a backboard and they really need to be. Now, you also have an error of commission. Now, this can be if somebody is trained to intubate, but they are not legally a paramedic, then they cannot perform that skill on a live person. So if you're EMT and you're in paramedic school and you are not performing a clinical, you're not operating as a paramedic student or as a paramedic, and you intubate, then that is an error of commission. Or, for example, if you have a paramedic who sutures a laceration, and that's outside of the scope of practice of what their state or what their medical director allows them to do, then that is an error of commission because they committed an act that exceeds their scope of practice. Now, you next have proximate cause. Now, that is the failure to act appropriately. That was the first event in that chain of events that led to that injury. So essentially, there was a relationship between the breach of duty and the harm that got caused. So, for example, if you fail to secure somebody to the long backboard and they result in a spinal laceration or a severe spinal injury, then that is proximate cause. Because you did not secure them to the long backboard, then that is why they had their spinal injury. And then you also have harm. That's going to be the end result. So for the example of the long backboard, that's going to be the spinal injury. If you have somebody who had a laceration that was sutured by a paramedic in the field, then maybe that is increased infection, or maybe it was sutured improperly. And all that is that's that proximate cause. That is the relationship between what you did or what you did not do and the harm that followed. Now, negligence is divided into three main categories. You have malfeasance, you have misfeasance, and then you have nonfeasance. Malfeasance that's you performing an act that you were never authorized to do, such as intubation or such as suturing. You are never authorized to do those procedures. Even if you did it correctly, that is not something that you are authorized to do by your state or by your local medical director. Then you have misfeasance. Misfeasance is you performed an act that you are legally permitted to do, but you did it improperly. So, for example, if I was going to give somebody, epi for an anaphylactic reaction, and I gave them 1 milligram instead of 0.3 to 0.5 milligrams, then that would be an example of misfeasance. I did something properly, but I did the proper drug, the proper treatment, but that treatment was performed improperly, such as the miscalculated drug dose. That is an example of misfeasance. And then you also have non-feasance. That is essentially you fail to perform an act that you were required to or expected to perform. An example of that would be is if your patient goes into cardiac arrest while you're transporting and you do not perform CPR while they're under your care. And that is an example of non-feasance. You're required to act, you're required to do something, but you didn't do it. And those are the 3 main ways that it's divided. You have misfeasance, malfeasance, and non-feasance. And so it's further divided at the state level, really, between ordinary negligence and a gross negligence. And these are standards that the states follow. Now, ordinary negligence, that can be, the way that the states look at it is it can be a failure to act or a simple mistake that causes harm. Okay, and this is much easier to prove negligence than under ordinary negligence than it is under gross negligence. So that simple act or mistake that caused harm may be an infiltrated IV, and that is something that can that you can get held under ordinary negligence. Now, gross negligence, that whenever you have a state that follows that, a paramedic will not be successfully sued, or a lawsuit against a paramedic will not be successful unless that paramedic has seriously departed from the accepted standards. So, for example, that previous example I gave about the infiltrated IV, obtaining IV access, that is an accepted standard. And it may have been, maybe it got misplaced after the fact, or maybe there was something that happened that resulted in it becoming a non-viable IV. It would be much harder for a paramedic to get sued or have a lawsuit raised up against them in a circumstance like that. But if a action is grossly negligent, so then that paramedic can be successfully sued. So acts that are grossly negligent, they are found to be willfully malicious under the law, and that's going to be that's going to involve a lot of litigation, and that's where your paperwork and the training standards and the protocols that you follow, that's where all that comes in. Now, we also have the Good Samaritan law. Now, the Good Samaritan law this goes into what we were talking about earlier about the duty to act. If you're off duty, you do not necessarily have a duty to act. So if I was off shift and I were to pass by a wreck, I would not have to stop. Or I could stop and I could help. But if I am off duty, I cannot accept compensation for the services that we provided. And so compensation can be anything. It can be monetary. It can be in materials, such as if you help somebody up out of their car and they hand you a water bottle, and during the process of them getting out of the car and you helping them up onto the sidewalk or onto the embankment or something like that, and they're like, hey, you know what, I appreciate you, here's a 20 for your troubles, or here's your water bottle, you look tired. If you accept any form of payment, any form of trade or anything, then that is payment, and you can be you're not going to be covered under the Good Samaritan law at that point. And that Good Samaritan law, what it was designed to do was it was designed to protect those who are off duty and do not have that duty to act, allowing them to provide care under good faith, under the understanding that they know that they are not going to get paid. They're not going to receive compensation for the things that they do. Now, we also have abandonment. Abandonment is that is a termination of care without the patient's consent. So, for example, if I were to have somebody who was unconscious, unresponsive, and they were in their home, and I would say, okay, you know what, they're unconscious, unresponsive, but they're clearly inebriated, and I were, pick them up, tuck them into bed, and then I were to leave. Well, that would be an example of abandonment, because that patient had a need for continuing medical treatment, especially if we're in their home and they're not recognizing that. And so what this can cause is, if that patient has any sort of subsequent injury or death, then we can be held at fault for it, especially if we had hands on them and it was a unilateral termination of care without the patient's consent. We decided electively that we were not going to provide care for that patient. Now, there's also some situations that may not require transport, such as somebody who had a seizure, but they know they have a history of seizures, and they're able to typically control it with their own medications. And they've been going to the hospital here periodically. They don't want to go to the hospital again. And they're awake. They have the ability to make medical decisions for themselves, and they're alert to person, place, time, and event. And then you also have the hypoglycemic patients. So, for example, if I get out to somebody and their blood sugar is 30, they're altered, unconscious, unresponsive, and we give them some oxygen, we get an IV, we give them some D50, we give them some D5, some form of dextrose, and we get their blood sugar up. They wake up, they get with it, and they don't want to go. Maybe they have been vomiting and they missed a meal, or maybe they took their insulin and then they vomited up their food. Well, then that's something that they can control, okay? And that's something that them, under their ability to make medical-minded decisions for themselves, they've elected that they don't want to go. As long as they're alert to person, place, time, and event, that's an important thing to understand. But that, again, that's a situation that does not necessarily require transport, but you do need to document accordingly as a way to cover yourself and protect yourself and your partner. And always follow your local guidelines. And if at any point you feel that there's something that is a little off about the situation, always contact medical control, and then you can do what it is that they say to do. Now, there's this last little subject right here is called res ipsa loquitur, and I'm probably saying that wrong, but essentially what it means is it speaks for itself. And this is what happens whenever the injury was sustained in your care, and there's no way it could have happened had they not been in your care. So, for example, if you have somebody who was dropped while you were unloading them out of the back of the ambulance with a stretcher, if they were dropped and there was a reason that they were dropped, period, and they got an injury from it, well, there's no other way that they could have gotten that injury had you not dropped them. Or if you're wheeling your patient into the room where they're going to be, and in the process of getting them into the room, you slam their fingers or you slam their arm into the doorway, and you cause a laceration, you cause a break of a finger or of an extremity. And maybe they get a subsequent infection that may lead to a hospital-acquired infection, and that may lead to sepsis. In that case, you could be found negligent due to the res ipsa loquitur, and that's just another way that they can prove negligence for yourself. So always remember that with negligence, there's 4 things that have to happen. You have to have the duty to act. You have to have that breach of duty. You have to have a proximate cause between your breach of duty and the harm that occurred. Okay, so duty to act, breach of duty, causation or proximate cause, and harm. And those are really going to be the big highlights of negligence and the things that you need to know.